3. Executive Department. President and Vice President. 1. Term, qualifications, and election. Qualifications. No person may be elected president unless he is 1. A natural-born citizen of the Philippines. 2. A registered voter. 3. Able to read and write. 4. At least 40 years of age on the day of the election. And 5. A resident of the Philippines for at least 10 years immediately preceding such election. Same qualifications apply to a vice president. Term and election. The president and the vice president shall be elected by direct vote of the people for a term of 6 years. The president shall not be eligible for any re-election. No vice president shall serve for more than 2 successive terms. Note: no person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. 2. Privileges, inhibitions, and disqualifications. The president shall have an official residence. The salaries of the president and vice president shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. The president, vice president, the members of the cabinet, and their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. They shall not, during said tenure directly or indirectly, practice any other profession, b. participate in any business, or c. be financially interested in any contract with, or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including GOCs or their subsidiaries. The spouse and relatives by consanguinity or affinity within the 4th civil degree of the president shall not, during his tenure, be appointed as a members of the constitutional commissions or b. the office of the ombudsman or c. as secretaries, undersecretaries, chairmen, or heads of bureaus or offices, including GOCs and their subsidiaries. The prohibition imposed on the president and his official family is all-embracing and covers both public and private office or employment. Civil Liberties Union versus Executive Secretary. B. Executive and administrative powers. The executive power shall be vested in the President of the Philippines. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Corollary to the power of control, the President also has the duty of supervising the enforcement of laws for the maintenance of general peace and public order. Thus, he is granted administrative power over bureaus and offices under his control to enable him to discharge his duties effectively. The powers of the President cannot be said to be limited only to the specific powers enumerated in the Constitution. In other words, executive power is more than the sum of specific powers so enumerated. The residual unstated powers of the President are implicit in and correlative to the paramount duty residing in that office to safeguard and protect general welfare. In Muap v. Romulo, the court upheld the reorganization of the DOH through EO 102 and 1165, as it was within the President's residual power to restructure the executive departments since he has the power of control over executive departments granted by the Constitution. The power to create ad hoc bodies is a residual power vested in the President in accordance with Faithful Execution Clause. C. Power of Appointment. Section 16, Article 7. The President shall nominate and, with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. Appointment to office is intrinsically an executive act involving the exercise of discretion. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproved by the Commission on Appointments or until the next adjournment of the Congress. 1. Regular and ad interim. Two kinds of appointments requiring confirmation. 1. Regular. Made by the President while Congress is in session. Takes effect only after confirmation by the Commission on Appointments. Once approved, continues until the end of the term. 2. Ad interim. During the recess of Congress, because the Commission on Appointments shall meet only while Congress is in session. Section 19, Article 6, 1987 Constitution. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproval by the Commission on Appointments or until the next adjournment of the Congress. Section 16, 2. Article 7, 1987 Constitution. Hence, when an ad interim appointment is bypassed, it expires during the adjournment of Congress and must be re-extended by the President. The mere filing of a motion for reconsideration of the confirmation of an appointment cannot have the effect of recalling or setting aside said appointment. The Constitution is clear. There must be a rejection by the Commission on Appointments or non-action on its part for the confirmation to be recalled. A bypassed appointment is one that has not been finally acted upon on the merits by the Commission on Appointments at the close of the session of Congress. There is no final decision by the Commission on Appointments to give or withhold its consent to the appointment as required by the Constitution. Absent such decision, the President is free to renew the ad interim appointment of a bypassed appointee. A bypassed appointee, or one whose appointment was not acted upon the merits by the Commission of Appointments, may be appointed again by the President, because failure by the Commission of Appointments to confirm an ad interim appointment is not disapproval. Section 14, Article 7. Appointments extended by an acting President shall remain effective, unless revoked by the elected President, within 90 days from his assumption or reassumption of office. 2. With or without Commission of Appointments confirmation. The President shall nominate and, with the consent of the Commission on Appointments, appoint a. the heads of the executive departments, b. ambassadors, other public ministers and consuls, or c. officers of the armed forces from the rank of colonel or naval captain, and d. other officers whose appointments are vested in him in this Constitution. The regular members of the JBC shall be appointed by the President for a term of 4 years with the consent of the Commission of Appointments. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and b. those whom he may be authorized by law to appoint. 3. Midnight appointments. General rule. 2 months immediately before the next presidential elections, and up to the end of his term, a president or acting president shall not make appointments. Exception. Temporary appointments to executive positions, when continued vacancies will 1. Prejudice public service, or 2. Endanger public safety. Limited to executive departments. The prohibition against midnight appointment applies only to positions in the executive department. 4. Removal from office. General rule. The power of removal is implied from the power of appointment. Exception. The President cannot remove officials appointed by him where the Constitution prescribes certain methods for separation of such officers from public service, e.g., chairmen and commissioners of constitutional commissions who can be removed only by impeachment, or judges who are subject to the disciplinary authority of the Supreme Court. Members of the career civil service who are appointed by the President may be directly disciplined by him, but their removal is subject to compliance with civil service rules. D. Power of control and supervision. Section 17, Article 7. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Control is essentially the power to 1. Alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties, and to 2. Substitute the judgment of the former with that of the latter. The power of control includes acting directly whenever a specific function is entrusted by law or regulation to a subordinate, directing the performance of a duty, restraining the commission of certain acts, reviewing, approving, reversing, modifying acts and decisions of subordinate officials or units, determining priorities in the execution of plans and programs, prescribing guidelines, plans, and programs, reorganization, transfer of unit, transfer of functions, abolish, consolidate, or merge units. Supervision is the overseeing or the power of the officer to see that subordinate officers perform their duties, and if the latter fail or neglect to fulfill them, then the former may take such action or steps as prescribed by law to make them perform these duties. This does not include the power to overrule their acts, if these acts are within their discretion. 1. Executive departments and offices. Doctrine of qualified political agency. Doctrine of qualified political agency, aka alter ego doctrine. All the different executive and administrative organizations are mere adjuncts of the executive department. This is an adjunct of the doctrine of the unitary single executive. The heads of the various executive departments are assistants and agents of the chief executive. In the regular course of business, acts of executive departments, unless disapproved or reprobated by the chief executive, are presumptively acts of the chief executive. There is a special class of powers which the President cannot delegate, e.g., declaration of martial law, suspension of the privilege of the writ of habeas corpus, executive clemency, among others, which are textually committed by the Constitution to the President. However, the power of administrative review is not among these quintessential presidential powers. Thus, the President can choose not to review the decision of the DOJ and delegate such power to the Secretary by virtue of the qualified agency doctrine. Note, the doctrine remains limited to the President's executive secretary and other cabinet secretaries. It does not extend to deputy executive secretaries or assistant deputy secretaries. The President's power to contract foreign loans may be validly delegated to the Secretary of Finance, provided that the contracting loan is subject to the President's approval. Executive departments and offices. General rule. The multifarious executive and administrative functions of the chief executive are performed by and through the executive departments. Exceptions. A. Cases where the chief executive is required by the Constitution or by law to act in person. Or B. The exigencies of the situation demand that he acts personally. The President may, by executive or administrative order, direct the reorganization of government entities under the executive department. This is also sanctioned under the Constitution, as well as the Admin Code. This recognizes the recurring need of every president to reorganize his or her office to achieve simplicity, economy, and efficiency, in the manner the chief executive deems fit to carry out presidential directives and policies. 2. Local government units. General supervision over local government units. The President shall exercise general supervision over local governments. The President shall exercise general supervision over autonomous regions to ensure that laws are faithfully executed. The President may suspend or remove local officials by virtue of the power delegated to him by Congress through the Local Government Code. The Constitution also places local governments under the general supervision of the President, and also allows Congress to include in the Local Government Code provisions for removal of local officials. In relation to local government units, LGUs, supervision includes the authority to ensure that LGUs are operating and acting in accordance with law and not ultra vires. However, the President cannot directly overrule the acts of LGUs, e.g., local executive orders or local ordinance, as he only exercises general supervision over LGUs, not control. Note, the President cannot lay down the rules, neither does he have the discretion to modify or replace the rules.